some of our not-so-good actors are.
Exactly. And Senator, thank you. I do want to reiterate that my colleague on the panel, I think, makes a persuasive case that we ought to calibrate the settlement disclosure requirements in this industry to provide the maximum benefit to both consumers and the good actors in the industry. So I think that's a critical piece. I myself have been persuaded about that. The question is when we move from that question to whether we ought not even talk about the subject. On that, we respectfully very much disagree. Let us take as a given all of the data that my colleague on the panel has talked about. And let us take as true the hypothetical lawsuit scenario that he outlined at the beginning of his testimony. Were the hypothetical to be true, the chief would never bring that case. It's a terrible case. We would never bring it. He would exhaust few, if any, resources on working on that case as compared to the other cases that he's got. And that's what I meant in my testimony by being able at some level to trust the judgment and expertise and the self-interest, frankly, of the folk who work in enforcement in this bureau, that they don't want information that is never going to be helpful and that they won't bring cases that are no good. At some point, legislation is unable to calibrate judgment, to regulate judgment. At some point in every Department of Consumer Affairs licensing agency, judgment plays a role. And if the data from this bureau can be looked at as being synonymous with it being careful and meticulous in enforcement, and we think it can, Senator, we have nothing to fear by allowing the CSLB to make these judgment calls. The bigger question is the question of whether it's overwhelmed with paper such that it's just drowning in paper. It's a perfectly legitimate point. And that's why when we hear the chief talking about working with industry partners to figure out how best to do this, it's, I think, the right way, very much the right way to go. By way of a counter hypothetical, and then I'll be quiet, it is true that in the hypothetical situation, we may not have, the settlements may not have been indicative of their potential problem, but here with Segway, they were. Here we have a pattern of very large settlements within a short amount of time, and once the CSLB actually looked at it, it found, quote, probable violations of law. When you're talking about life and death situations like you are here, very few things that come into this legislature really truly mean life and death like this does. It makes sense to afford the board the opportunity to look at some segment of these settlements to see whether or not tragedies like this can be prevented. Exactly how it should be done should be calibrated carefully in a conversation between the board and the regulated community and consumer groups.
Okay, and if I may say, with the legislature, because
that's a given.
consumers too often, as Ms. Murray indicated, are one-on-ones dealing with their own tragic loss or their small home defect, whatever it is. And we're trying to craft a solution that will give the board the information. And I really do welcome the analysis that you're going to do, because I think it's also an opportunity for continuing education for architects and contractors and others. If there's particular kinds of issues like water intrusion that really has now been identified for us. So it seems to me that what we're coming down to is getting a beginning way, which can be refined later, but I frankly wouldn't want to put off legislation until we make sure that every study is done, but to do what Mr. Howard suggested, give the board a tool that other boards have, and have you then come back and let us know.
Well, and I think they are working.
I think they are, and we appreciate it.
Really do appreciate the effort
Really,
and the leadership that you're taking in
done a
that
great job.
regard. Mr. Cameron, a question, because you indicated on the obviously the larger subdivision projects and the lawsuits that come, and the developer, it's generally the general contractor who is the one who is initially makes the settlement. But then that general contractor, I believe, then files suit or has, towards the subcontractors that worked in the project to recover, or it's some of the damages, or or files an action against the architect or the engineer in the project, or everyone who probably had their hands on that project in some form or another is also going to be sued, and at some point there will be a settlement related there from their insurance carrier. But we just heard earlier that the geologists, the architects, their board today is able to take those settlements and work with them and calibrate them in a manner that does not seem to be or create a problem for the industry, but does provide information, as they mentioned, on a very small number of individuals or firms to take action on. How do you explain that?
So I guess the first response would be, in answer to your question, is that we saw this a lot in the indemnity wars that took place in this legislature between 2005 and then up to 2011. And this is what you get in construction defect litigation. You get a lot of people doing this, right? And they're all pointing fingers at each other, and they're all hiring experts, and their experts produce their own forensic reports. And when you ask our members and when you ask the trade contractors, you'll hear from them, you'll hear from me, that if we're going to, after 5 years of litigating this and we finally thrown up our hands and we can't figure out who is really at fault, or even if there is really damage, we've just decided to pay some money to make it go away. Now we're going to go up to the CSLB at an administrative level and redo this entire process, because whoever the CSLB points a finger at is going to have their own expert forensic studies already prepared that say it's that guy, it's the other guy, it's somebody else, it's the roofer, it's the framer, it's the window installer. I don't think it's going to be so simple. I think it's naive to think that. Like I said, is there something that could be done? Perhaps. I'm not closing the door to doing something that protects our own customers. That's not what I'm saying. But that in particular, and I want to point out at least this much, in terms of Segway, Segway's not a member of ours. I'm not defending Segway in any way, shape, or form. I'm just going to point out from the facts that have been put out so far, we're looking at here a general contractor who happened to have 3 previous settlements totaling a large dollar amount. Now, I would ask this question: should the CSLB have acted in response to the tragedy in Berkeley? Should they have acted in response to that regardless of whether or not they had been involved in 3 previous settlements? My suspicion is they'd say yes, heck yes. Because they aren't as far as I know, the other 4 companies that have been cited haven't been identified as having previous settlements. Now, I won't be surprised if they had previous settlements, but I don't know that, and that's not holding CSLB back. You have a real problem. You have tragic victims, and they're responding to that under their existing authority, and the system is working.
And then I would just say that the system is working related to the Board of Architects, geologists, who are getting the same settlements that your members and those general contractors are paying. Then that flows down from the suit that your contractors are suing them for, and they are settling with your contractor. That settlement is going to those boards today, and they're able to calibrate it. They're able to decide, and on a very small number, they found that there may have been a problem here that they need to pursue.
Yeah, the only thing I want to point out here is that the types of insurance that are applicable. For design professionals, they're off on their own. For trade contractors and for general contractors and for owners, they are typically covered by a wrap policy, which means everybody is together, which means you won't see those kinds of cross litigation where you're having separate settlements, which is why it looks like when you look at Segway and you point to a high dollar amount, how much of that was contributions from trade contractors that are nowhere visible in the settlement?
I see. That's very good. Thank you for that explanation. Thank you all very much for being here and being part of the conversation today. So now I'd like to kind of open this to public comment, and would Mr. Grant, Consul General of Ireland, the Honourable Philip Grant, and then Ms. Donohoe, if you would like to say something. No, very good. You can sit here if you'd like. Yes, of course. Thank you, Consul General.
Not at all. Thank you very much.
Appreciate your being here today.
I want to thank you, Mr. Chairman, and all of the participants and those who attended this afternoon's hearings. And not only for the hearings today, but also the great support and sympathy which the families of those impacted by the tragic events in Berkeley last June. I think that the Donohoe, the Burke, Culligan, Miller, Schuster, Walsh, Beery, Cogley, Fahy, Flynn, Halpin, Murray and Waters families naturally take a very deep interest in your proceedings. You know, we're very conscious that this isn't a question of nationality. Clearly Ireland has been very deeply affected and impacted by the tragedy that happened in Berkeley last June. I don't know how many hearings of the Senate committees get national coverage on third countries' news, but it was the second and third news story on the Irish newspapers this morning. So it will give you a sense of the degree to which I suppose we've all been impacted by that tragedy and how closely we're following what has taken place. We very, very much welcome the work that has been done by the city authorities in Berkeley, by the district attorney's office, by the state licensing board, by all of the trade bodies that are involved in the construction industry. Ireland's ties with California go very deep. We had our Minister for the Environment here in Sacramento on St. Patrick's Day for an event honouring the Irish contribution to California on the Assembly floor. And there's probably very few communities in California that are as closely tied to the contractors and the construction trades as our own. So it was very encouraging to hear the message of support that we got from the legislatures, from the administration, and especially from the trade bodies. I suppose if there is a message that I know the families would like me to say, the block where Library Garden Apartments is located, as Senator Hancock knows, is a very small block. At one end of it is the Berkeley High School. At the other end of it is the Berkeley Public Library. And as I said, this is not about the nationality of the people who were on the balcony. At that time, they were residents of the state of California. And if it is the case that in the investigations that everyone is carrying out, that it is discovered that there is a clear and present danger to the residents of California, then we all truly hope, and I know, because we've spoken to so many people who are involved in this, that it is in everybody's interests to see the necessary changes to industry standards and practices so that we can make sure that, you know, we can prevent such a needless tragedy from ever happening again. So just to thank you very much again for the opportunity you gave us today, particularly because so many of the families can't be here, to allow them to participate, to listen in, and to get a sense of how much work is actually being done in this area. So again, thank you very much.
Thank you, Mr. Consul General. Appreciate you being here today. Yes, sir. Good afternoon.
Good afternoon, Senator Hill. Senator Hancock, Senator Hill, I applaud you for the work that you've done on this and the work that you will continue to do. My name is Richard Zittrain. I am a professor of law at Hastings, at UC Hastings, and I specialize in legal ethics. And I was engaged in a fairly lengthy dialogue with Nate Solov of your office, and he asked me to come up here this afternoon to give you my perspective. I've been very involved in the area of legislation regarding secrecy for the past 18 years. I have written, along with staff members here in the Senate and the Assembly Judiciary Committees, anti-secrecy legislation for Darrell Steinberg, for Maria Escutia, for Fran Pavley and others, and I'm the author, or I should say drafter, the senators are the authors, of two versions of what we call the Sunshine and Litigation Act before the United States Senate, the most recent of which was filed with the Senate in 2014 and co-sponsored by Senators Blumenthal from Connecticut and Graham from South Carolina. And I am here to give you a kind of bird's eye or blimp eye view of this entire issue, which goes far beyond the issue of construction defects. And it is, to paraphrase a famous phrase, secrecy kills, and absolute secrecy kills absolutely. There are people dying as a result of something that came up in the testimony of 3 separate people this afternoon. The fact that the settlement agreements that have been written in the civil litigation in these cases have not been exposed to public scrutiny. And so what you have is regulatory agencies who say, well, we'd love to find that stuff, but we've got to go online to get it, and sometimes it costs money to get online. And it's very, very difficult to get it with our limited resources. And then you also have licensing boards who are going to be who could, under certain circumstances, be overwhelmed by the amount of the number of cases that come before them. And in my discussions with Nate and emails back and forth that I believe your other staff member, I gather you're chief staff member for this committee, counsel for the committee. What we've been talking about is not only what you're doing with this admirable litigation, not only what you're doing by way of requiring this information to be conveyed to the licensing board, but also my strong recommendation to you, and I'd be happy to continue to work with your staff members, is that you have the opportunity here to require not only the reporting of administrative actions resulting in settlements over $50,000 or $50,000 and over, and I do hope that it remains $50,000 and over and not the other way around, but to require the reporting of the underlying information, that is the factual information on which the allegations were based. That is, the underlying information forming the basis of the allegation, the defenses, as well as the settlement or any judgment in a case of civil litigation. Why is that important? Because rather than merely giving the boards the information, that will give the public the information. And you have a good piece of legislation that will now impart information to the boards, but may, in some respects, as my friend and colleague Mr. Howard pointed out, in some instances possibly overwhelm those boards. But if the reporting requirement is to report the underlying information that caused the lawsuit to occur, for example, or the sanctions to occur, then the public has access to it. So imagine a case that I've been involved in, which you've heard of, which is the GM ignition cases. And the issue there was, did GM report what was wrong with the ignitions that therefore caused the airbags to fail to the National Highway Traffic Safety Administration, such that the public could become aware of it? And also, did NHTSA, which hadn't done such a good job until recently, did they report it to the public? Because when the public knows, the public right to know kind of lets a little pinprick into that balloon and allows the truth to become free before the entire public. And that takes pressure off of licensing boards. Because if there is a repository by which members of the public can look up the history of any contractor and make a decision for themselves whether they want to employ that contractor, then a lot of the pressure is taken off a licensing board, be it NHTSA or the California State Licensing Board that works with construction, because the public's right to know can then allow them to make a decision in the marketplace about whether this is a company that they want to hire.
Very good, thank you. I'm going to have to, you made a very good point. Thank you so much.
And that's
for
all that I
Professor.
wanted to say. Thank you,
It's wonderful,
Senators.
I appreciate it. We do have a few more speakers, I'm sure, and we have our legislative session begins in a few minutes, so thank you very much. Really appreciate you coming up for this. So if we could have a few, just if we could be as brief as possible. I know that's
Thank you, Mr. Chairman, Senators. I'm Bob Raymer, Senior Engineer with the Building Industry Association. And special request of you, Mr. Chair, and the Senators, to the extent that it's possible, any encouragement you could provide to get the prompt release of the full forensic report would be very helpful. In response to a question raised by Senator Hancock earlier today, it is the Department of Housing and Community Development that has the lead authority for developing and proposing building standards for residential occupancy, such as that where the tragedy occurred. They've been waiting very patiently, dating back to October. They're ready to roll up their sleeves with a number of other agencies, including the Building Standards Commission, Division of the State Architects Structural Safety Division, and perhaps dozens of private sector entities to start working on this. In response to another question that Senator Hancock had, does HCD currently have the authority or do they need statute? They've already got the authority. Back in 2008, HCD proceeded with the development of the first set of green building standards, which included, amongst 24 other things, that requirement that timber not have a moisture content exceeding 19%. They did that. They proposed that. They took it to the Building Standards Commission. It got adopted as a mandate. It took effect in 2011. All of that was done without enabling statute. They had the tools they needed that dated back to the late 70s. So with that, anything that you could do to get the release, thank you very much.
we will do that, take that on.
And would that be the district attorney's office, or who has the forensic report?
Well, when legal matters are pending, administrative matters such as that with the State Contractors License Board, the document is sort of embargoed. And to the extent that those that have the document are able to complete their work, I know the DA has already decided not to proceed with charges, so right now it's my understanding that CSOB is finishing their work, and at the Building Standards Commission meeting last week, we were told that perhaps that document would be released in the next 30 days. It'd be awful to get to 30 days down the road and find out, well, somebody else has it.
We'll try to help with that.
Thank you,
Very
sir.
good, thank you.
Mr. Chairman,
afternoon.
members, how you doing today? Mr. Eddie Bernanke on behalf of the National Electrical Contractors Association, California Legislative Conference, Plumbing, Heating, and Piping Industry, United Contractors, and the Wall and Ceiling Alliance, representing a little over 4,000 union specialty contractors throughout the state. I just wanted to make a couple comments specifically on the size and scope of any proposal that you and Senator Hancock would like to pursue further. You know, it was mentioned both by Mr. Howard and Mr. Camerata that, you know, the scope issue for our contractors is very important to keep in perspective as you look at this issue. They enter into settlement agreements for things outside of defect litigation, and that includes payment disputes, workers' compensation issues, and in some cases, because we're all union contractors, our grievances and our CBAs could be considered settlement disputes as well. And so when we look at this from a perspective from the contractors, because there's so many of them on so many projects, that we don't want to overwhelm the good people at the CSLB with hundreds of thousands of settlement agreements that may have zero ramifications on the defect side, or in cases that would happen in the tragedy in Berkeley. And we'd want to see that, you know, any proposal moving forward would really focus on what would be useful by the license board to sort of separate out the bad actors in the industry versus the good ones. So just wanted to make sure we got that on the record. Thank you very much.
I think we're all going in the same direction. Thank you.
Thank you, Mr. Chairman. Members, Todd Bloomstein, afternoon. Mr. Chairman, Todd Bloomstein for the Southern California Contractors Association. Firstly, my condolences and sympathies to the victims of the families. We are truly sorry for your loss. Just very briefly, a couple points, Mr. Chairman. Civil settlements aren't necessarily a symptom of faulty work. They're symptoms of an extraordinarily litigious state, and very litigious in this area of the law. I asked our contractors, which are all union engineering contractors, so they are the dirt movers, the ones that do the initial grading. All of them that have worked on any condominium jobs or attached housing have been sued. All of them have been sued, and all of them have agreed to civil settlements. And many of them, until most recently, have chose not to work on these projects because they knew they would get sued, although things are turning around now with the advent and popularity of wrap insurance policies. Just one point to bring out, and then I'll close. But the CBIA represented that there could be 50,000 to 120,000 settlements on individual structures. Where are all the complaints going to the CSLB? If each one was harmed or each individual homeowner was damaged, shouldn't they be filing a complaint with the CSLB alleging they were damaged? It would make sense in my mind that if that occurred, then the CSLB would have the lead to go after and start an investigation. SCCA really prefers the approach that the city of Berkeley is doing, a highly enhanced, highly targeted inspection of dangerous facilities. We think that's the most direct approach to ensure this tragedy doesn't happen again. Thank you for your time, sir.
Thank you very much, Todd. Appreciate it. Others here to speak in the public comment? Hearing no one, thank you. We will, well, first of all, thank you to all of those who were panelists and participated today in the discussion. And thank you to Senator Hancock for her leadership and being part of our committee today, hearing today. It's very helpful and insightful. And I just want to say that we will take what we learned today and really work with it. I think I like the word calibrate, because I think that word is the one that really fits as we refine how this will work, and working closely with the State Contractors License Board, because we have to find that that point that will allow them the opportunity to find those problems, those bad actors if they're out there, but also not be a burden on them or a burden on those contractors who are doing a good job and are subject to the challenges that California presents to them from a legal perspective, and those nuisance suits that I think every contractor is faced with at one point in time or another. So we will be working on that and working to refine that. Senator Hancock?
You know, really, you've put it very, very well. But we are going to work hard on this, and we are going to get it through. I appreciate the suggestion of more code enforcement. That, of course, puts the responsibility on local government, and we need to find a way to also make sure that there is responsibility on the part of private builders so that we can identify in companies that may not be doing a good job. We can learn about design defects that might need to be improved on, and we can assume that we are a group of people with a social contract with one another, and that we want the buildings that we build to be safe and beautiful and enhance human life. And I think there are many ways of getting there. And I thank Senator Hill for his real leadership on this issue, and we'll continue to pursue it for the rest of this year. And I do want to thank especially the licensing board, because your very thoughtful comments and I think your suggestions as we move forward will help us do that calibration that could lead to good legislation. Thank you all, and I really want to thank the family that's here and the Consul General for coming as well. Your steadfast focus has been very important and very helpful to us.
Thank you, Senator Hancock, and Ms. Donahoe, thank you for being here, and again, our condolences and our thoughts are with you on that too. The hearing is adjourned. Thank you.